Welcome back. Today we're going to talk about important terms associated with your First Amendment protections of freedom of religion and freedom of the press and freedom of speech. So let's get started. Starting with freedom of religion, in the First Amendment there are two specific clauses that break down your religious freedoms and the guarantees that the Constitution gives you. You have the Establishment Clause and the Free Exercise Clause. And the Establishment Clause prevents Congress from establishing a national religion. So Congress can't ever say, everyone in America is going to be Christian or everyone in America is going to be Hindu. So they can never come out and establish or truly show a bias towards a specific religion. Then we also have the Free Exercise Clause, and the Free Exercise Clause protects your ability to exercise your religious beliefs as long as those religious beliefs don't infringe on the rights of someone else. So for example, if my religion tells me that I have to sacrifice 3 humans twice a year, then I wouldn't be able to do that even though I'm practicing my religion because that infringes on somebody else's rights. So both the Establishment and Free Exercise Clauses can be found in the First Amendment. Scooting on then to freedom of speech, and I'm just going to get all these terms up here for you. To start off with, there are different types of speech. You have pure speech, and then you have symbolic speech. Now, the speech that you and I are most familiar with is this pure speech, and that is best defined as a verbal expression of thought or opinion. So if you walk into class and ask me who my favorite president is, and I tell you FDR, obviously, that's an example of pure speech because I'm verbally expressing my opinion on that specific issue. Symbolic speech is also called expressive conduct, and that is basically any other form of expressing thought or opinion that is not verbal. So, for example, if you walk into my classroom and you see a statue of FDR by my desk, you could probably assume that I kind of like FDR. So that would be an example of symbolic speech. You know my feelings on an issue, but you haven't heard me verbally express them. Next, we have defamatory speech. Defamatory speech is speech that is intended to hurt someone's character or to defame them, to make them look bad, and it's false speech, okay? So we have two different types of defamatory speech. We have slander, and then we have libel. Slander is spoken speech, and then libel is written speech, okay? So if I am bashing somebody verbally, then I would be slandering them. But if I was writing something down or if I put something on social media or anything like that, then that would be an example of libel, and neither of these are protected by the First Amendment. Moving on to seditious speech. Seditious speech is speech that is like intended to cause a problem, okay, intended to stir up stuff. Whenever the Supreme Court tries to figure out if a certain speech is seditious or if it's protected by the First Amendment, they use 3 different tests. The first test that they use is the clear and present danger doctrine. And the clear and present danger doctrine is basically the Supreme Court saying, does this speech, this specific speech in question, does it present a clear and present danger? So does your speech immediately make me want to do something violent, okay? Another test that is used by the court is the bad tendency doctrine. And this doctrine is, it's basically, if your speech has a tendency to lead to illegal action, then it's not protected by the First Amendment, okay? And next we have the preferred position doctrine, and this one's always been kind of difficult for students to understand. Basically, the idea behind the preferred position doctrine is that the First Amendment's protection of freedom of speech is so vitally important, it's so foundational to our society that the government should almost never be able to limit your freedom of speech, okay? So the idea is that you should be able to say whatever you want, but you start to lose those freedoms once you start acting on something. So you can say whatever you want about whatever, but when your actions start to become dangerous, then that's when the government should limit your speech. So the preferred position doctrine is basically the idea that the government should not limit your speech, but they should limit the actions that may come from that speech. And moving on then to freedom of the press. Freedom of the press is extremely important, as we have seen in the All the President's Men movie. 2 terms I want you to know about this: censorship and prior restraint. They basically go together. You've heard censorship before, that idea that certain things shouldn't be published because they are they are sensitive national security issues, or maybe they're just inappropriate or something like that. Prior restraint is the specific right of the government to censor information before it is published. And according to numerous Supreme Court cases, the government cannot use prior restraint unless the speech or the information that's about to be published is sensitive to national security. Okay, so if there's something that's about to be put into the newspaper, and government members deem that it's possibly going to cost American lives or put America in a tight spot, then that speech could be censored, or that information could not be published, possibly. And last but not least is a gag order, and I'm sure you've heard of this before whenever you watch crime television shows. A gag order is an order from a judge to prevent lawyers or anybody involved in a case from talking to the media about a case until that case is over. Okay? Now that is obviously a 100% violation of the First Amendment's freedom of speech. However, the freedom of a fair trial is deemed more important than free speech in this specific example. And we'll talk about a Supreme Court case that deals exactly with this. So if you have any questions, let me know. See ya.